All right, welcome back. It's time for us to get right into the news review segment. And today, on the news review segment, as always, the segment is interactive. We do want to hear from you throughout the show. So kindly join us with your WhatsApp line, WhatsApping us on 0204447033. Number is there on your screen. If you happen to be watching us outside Ghana, you can also prefix that number with +233. The hashtag is Breakfast Daily on all social media platforms, and so you can, as you're watching our streams, you can also comment there as well. Well, my guests are here, they're seated. Let me introduce them to you. But before we do that, just give you a sense of the topics we'll be tackling this morning. We're looking at the vacant seats saga, all right, the Supreme Court to rule today, all right, and so we'll be delving into that. What can we expect from the Supreme Court? John Mahama proposes political solution to the impasse that's going on. Then we are looking again at the 2024 elections. Secondary Court clears Joanna Jan Kujo to contest. And so these are some of the topics we'll be delving into. I've been joined on the set this morning by Richard Mensah. He's the head of programs production at 97.3 CTFM, as well as Elvis Dako, the editor of the News Center newspaper and newscenter.com. Gentlemen, you're both welcome.
Thank you.
How you all doing?
How by God's grace, once man is alive.
Yeah, okay.
Life is first, anything else is second.
Yeah.
Very important.
Yeah. Anyway, let's get right into it. The stories are here on ChannelOneNews.com. Let me just begin by reading that. The vacant seats saga. Now, the Supreme Court to deliver judgment today. So I'll quickly read that story for you. The Supreme Court will today, Tuesday, November 12th, deliver judgment on the Speaker of Parliament, Aban Bagben's decision to declare 4 seats vacant. At the last hearing, the Attorney General challenged the legality of the Speaker's continued representation by Thaddeus Sori, citing a lack of approval from the Public Procurement Authority. Now, during Monday's hearing, the counsel for the Speaker of Parliament, Thaddeus Sori, did not appear in court as the Supreme Court prepared to deliver its ruling regarding this contested decision. Now, the Chief Justice, Gertrude Tokonu, after listening to the presentation by the Attorney General, noted by court the judgment of this court will be delivered Tuesday, November 12th, 2024. At the heart of this case is Speaker Bagben's decision to declare 4 parliamentary seats vacant, a move he made under his interpretation of Article 97(1)(g) of the Ghana Constitution. Now, this ruling has sparked considerable legal and political controversy. Majority Leader Afenyo Marking has argued that Bagben exceeded his constitutional authority by unilaterally vacating the seats without judicial oversight or the option for by-elections. In response to this contention, the Supreme Court issued an interim injunction to halt the implementation of the Speaker's ruling while the matter is being decided. All right, so the story goes on and on there, but I can break into it and let's hear from my guests this morning. Let me start with Richard Mensah.
Well, this case has caught the sense of the nation because of the implication it has on our whole governance structure, i.e. Parliament itself. Also because we are left with some few days for Parliament itself to rise, and then we go into the December election. That is December 7th. So the life of this Parliament ends on January 7th. That is when, January 7, 2025, that's when they will be dissolved and then a new one takes over. Prior to this is an election year, so you also have urgent matters such as the budget, the 3 months budget for the running of the states after the elections. No matter who wins, that's what must happen. And therefore, there's the need to take care of that. And also the fact that we've seen because, the life of this parliament began with acrimony. and it looks like it's going to end with acrimony. And that is rather unfortunate. But in all this, you would call for calm heads to rule. And then also, for me, what I see about this is that, look, in all of this, the speeches and commentary by all sides involved must be conciliatory, and they must always adhere, or they must always remember that it is for the good of the nation. So the elected people are there, the executives are there, then the judiciary. Now today the Supreme Court would deliver its judgment, whichever way it goes. And the story has explained it, what Afenyomakin had problems with. That is the Speaker's resolve to rule on the matter. He says it was not a ruling, but it was an information. That is, to his mind, the Article 97 Clause 1 is very clear. So he just went ahead to just say that, okay, once this has happened, the consequence is this. That's fair enough. Afenyo and co are saying that, no, that doesn't lie within. In fact, some lawyers have argued that even to trigger that, the jurisdiction is even not the Supreme Court, that is the High Court, that you trigger that kind of because it's a human rights thing, you trigger it and then they make a pronouncement. So currently I know somebody, in the midst of the confusion, somebody has filed a case in the High Court. Okay. But what these people are seeking for, what Afenyomakin, majority leader, is seeking for in this particular instance, is constitutional interpretation. One, did the Speaker have that right to pronounce for them? They say that that pronouncement he did on the floor of Parliament amount to usurping the powers of the Supreme Court, amounts to interpreting that very particular article, and therefore that needs to be reversed. When it's reversed, then status quo ante remains. And then two, he was also looking at the fact that even with the article in question, it doesn't expressly give the right to forfeit your seat in this manner if this is what is done. So you've heard the argument when Attorney General Joe Gate and co appeared before court. They were saying that in any case, I heard arguments from them that in any case is looking at the life of the next parliament. So the next parliament's life has not begun. So for now, people voted you into parliament to go and do A, B, C, and D. And you are there to do that. So the Supreme Court would rule on it, whichever way it goes. Whichever way it goes. The very first question I ask myself is that, where do we move from here? Where do we move from here? Whichever way it goes. Whether the ruling says that, well, the people have vacated their seats, good. Where the ruling says that, no, considering the circumstances, this particular clause cannot be activated to mean that you've lost your seat. In any case, would have business of Parliament to perform. Now, what we've noticed from the various grouping is that they've all taken entrenched positions, and I don't think it's good for.
No, it's not.
One, the Speaker himself. Two, the majority leader, and now three, the minority people who raised it. And I'm using the words carefully because currently that is how it is. So yes, and these three people have taken entrenched positions. Yesterday I paid particular attention to the press briefing by Afenyomakin, and that worried me a lot, especially the narration that, look, I've had people have gone to Speaker. I was hoping to hear that I have made the overtures, or we've tried to meet, apart from the fact that he said so it was somebody, and then the Speaker told him that he should meet at a particular time. He was there, he couldn't meet the Speaker, and then the next moment they say, okay, following day we are going to court, so go to court. It tells you that the relationship is not that cordial. You don't need, it doesn't need to be cordial, but all it needs is a working environment to ensure that work is done. Now when people take entrenched positions, everybody will try to exert whatever right he or she thinks he has, and that is what is happening. I think the Speaker had a perfect opportunity to prevent this when they came to Parliament the last time. But the argument has been that, look, if the people are refusing to come there, then you want me to recognize what? because conveniently, you see, even yesterday, conveniently, they've not been able to say that he's disobeyed the Supreme Court ruling. No, conveniently, and he is also finding ways conveniently to do that, because in the first instance, when they came, that was the first time he announced that this is what I've had from the Supreme Court, and he ended it there. Now people are saying, okay, so why just appear in the chamber and then argue your point that, Mr. Speaker, and me, I also think that would have been the right thing to do. Mr. Speaker, there's this ruling from the Supreme Court, and it's based on your pronouncement the last time that the NDC caucus is behaving this way. In order to make it very clear, please, Mr. Speaker, are you in favor of what is happening? That one, you put the question direct and then see what because when you go and ask him, I didn't see my seat, somebody has taken over my seat, he will conveniently say that he is not the one to arrange it, which is the truth. Which is the truth. Now he says that he is not ruled because in that particular information that he says he gave to Parliament on the day, nowhere in his conversation or in his commentary did he say that because of that, you people, you are now minority, you people, you are majority. But the people just inferred that, okay, if you've declared 3 seats vacant, then obviously we are looking at numbers. It's a numbers game. So they immediately we become. Now they've also conveniently if you watch their commentary, they are not attacking the Supreme Court ruling which says that it should stay his hands off until the main case is declared. They are saying that we had a conversation in Parliament. Now the Speaker told us this. Let the Speaker come and tell us that what he did the last time, he's reversing it. You see, and everybody is being sly here. All it's telling you, everybody is showing the small power that he has. That is not good for our democracy. And this, you see, the blame lies on these 3 parties that I've mentioned. These 3 parties, the blame lies at their doorstep. The Speaker himself, and I thought he had a perfect opportunity to have settled matters. Why? The point is that I'm not sure with the ruling of the Supreme Court, Speaker will say that he wouldn't obey it. This constitutional interpretation. This constitutional interpretation. So they interpret it and then give you, so you obey it. So what then is the matter in then trying to correct, and then let's return to the status quo the previous time, and then we wait for the Supreme Court. Supreme Court, and the day of when his case was dismissed, the Supreme Court gave indications that they will be doing this case yesterday, and that they will ensure that it's fast track, because in the words of the Chief Justice, he thinks that the stalemate in Parliament is not good, and therefore they must do what they can do in their power to ensure that they return. They will do. So there was clear indication that this is not going to be one of those cases that was going to prolong. So why don't you correct? Let's come back to the table and then we move ahead. But you are also looking at the other side. Did the other side have genuine intentions to do that? Because one, I'm sitting here and I'm like, okay, so you've called Parliament. You've recalled Parliament. We need to come. There are businesses to be discussed. And then on the day, you didn't even show up. You didn't even show up. There was the excuse that there was a caucus meeting. You know, and then one of them, who is a senior, he's not a backbencher, who's a senior member, on air. When we spoke to him, he said, I don't know whether we have a caucus meeting
or not.
Yes, but then I'm going to check. And that was the caucus meeting. Now, they came back with some stories, and then Kennedy Jipon said that, look, the best thing to have done was to inform the Speaker that we are having a caucus meeting. Because sometimes Parliament, we've been here before, Parliament will say they are sitting at 10 a.m. and they will end up starting the sitting at 2 p.m. Which is on air. One of the parliamentarians also, there's been times they had to wait for people who were mid-air coming. They had to wait for them to arrive, and they whisk them to the chambers, and then they start business. So why wouldn't you even go there to make your case? He's explained that I'm not going there to make my case because I don't think I would want to sit on the other side of the aisle before arguing my case. I think the correction must be done by the Speaker before we enter. Fair enough. In all this, one thing that intrigues me is the commentary by the Attorney General when yesterday he sought to say that the non-appearance of the speaker, the legal representation for the speaker is a show of disrespect. And I was wondering, but the last time his argument in court, the last time, if you listen to him carefully, were in twofold. First, the fact that he thinks Tadiosori shouldn't be representing the speaker because PPA they went for sole sourcing and all that. PPA had not filed for him. And then the second one, that he doesn't think the speaker self should be party to the suit.
Okay.
Because this is merely constitutional interpretation. And if it comes to that, he is the lawyer for the state, and therefore it solely rests on his shoulders. Now, if you've made all these arguments and you appear in court and the people didn't show up, why would you be worried and be saying that it's a show of disrespect? In all this, I think reason must come to bear on all sides involved. It doesn't do them any good. The aesthetics are not right to be showing off power. Power for what? When we are left with just some few days to go for elections, let's get the business of government done. Let's get ourselves. You know, I would have with this energy is rather used in for the energy of the NDC group is used in opposing whatever legislation that has come before the House. That has come before the House that they think that is not in the interest of the public. But not to be wasting it on things that are really not helping anybody.
Thank you. Elvis.
Yes.
Your thoughts on this, as we are expecting them to rule today, where do you feel, I mean, of course you can't preempt them, but after everything that's happened, what are you expecting today from the Supreme Court?
I've said it on all the papers say, and I'll say it. The whole problem is Bagman, and until everybody tells him that it's him.
Why do you feel so?
The whole problem is Bagman, and it is simple. There's no confusion that will be explained away without Bagman. Bagman is the cause, and Bagman is the only one that can solve it. Let me read what the U.S. Supreme Court has said. It said when the Supreme Court rules on a constitutional issue, that judgment is virtually final. Each decision can only be altered by rarely used procedure of constitutional amendment or by a new ruling of the court. That is the U.S. Supreme Court. I'm saying Bagby is the problem, and until we tell him in the face, we will never have any end to this issue. Nobody should think that the Supreme Court rules today will end the issue.
Really?
Yes, of course. Bagby is the problem. I believe, and I support Bagby's decision that once the people have filed on a different ticket, they have vacated their post. That is my position. That's my understanding of the Constitution. And I support his decision that the people have vacated their post and the seats are vacant. That I support 100%. That is me to my understanding of the issue.
Okay.
But when he made a pronouncement, I support it. But the moment the case went to the Supreme Court, and the Supreme Court imposed an injunction, I expected Bagby to say, I made this pronouncement. The Supreme Court says it should not be executed. For that reason, my decision is suspended. If Bagby had made that pronouncement that day, when he said he has received the injunction, if he had added that, my pronouncement is on suspension based on this injunction, all the brouhaha we are going through will not be there.
Would have stopped,
We would have just been waiting for today's ruling from the Supreme Court to finalize the matter. But the fact that he failed to add on that day that because of the injunction, his pronouncement is on suspension. That's why we are having all this. Because if you ask the minority people, they tell you that Bagby has not said that he has changed his decision. He hasn't said his decision is on suspension. And that is why they will also continue to refer to themselves as what? Majority. And the truth is, Parliament is about numbers. When after elections they go to Parliament, even before they go, we know who is majority because we know who has won what numbers. So once you make a pronouncement that depreciates one party's numbers, it meant that they are no longer majority. This is direct from your pronouncement. So it is Bagby that has created all this confusion. And as I said, I support his ruling. But at the point where Supreme Court has imposed an injunction, I expected him to say, based on the Supreme Court's decision, injunction, my pronouncement is on suspension, pending the final outcome of the Supreme Court. If that has been said, all this all this confusion we are witnessing today will not have been there. That is why I'm saying that whatever we say, don't blame the NPP, don't blame the NDC. Blame Alban Bagbin for the problems we have so far in Parliament. He is the one that caused it, and we should not hide it. And if we are not telling him that is the problem, and we are hiding around, and the minority says it, and the majority says it, it's waste of time. Because what is causing the entire problem is that pronouncement that he is here to vacate. That pronouncement that he is here to say is on suspension. It's why we are having all these problems. So for me, whilst I support that decision, I am convinced in my mind that once they filed on another party, they have actually left their parties that brought them to Parliament, for which the seat should be vacant. His failure to add on that day that based on Supreme Court injunction, my decision on suspension until Supreme Court pronounce it. That's why we have all this. If they have said that, and this will no longer be going out that they still the majority, because they said they are majority based on Bagbin declaring the seat vacant. So if Bagbin has said the decision I took to declare the seat vacant is now suspended because of Supreme Court injunction, and this will no longer go anywhere and say they are majority. They would have been waiting for the Supreme Court to declare before they take that position. And all this, the confusion that we have gone through till today will not have been there. So for me, truth of the matter is simple. That is the problem. And the fact that he refused to add that he has suspended his decision that day, and the position he has taken when he went to the court to go and argue that the Supreme Court has no power to intervene in his actions, and he lost the case. And now he has refused to enter an appearance. There is no guarantee that if the Supreme Court pronounced today, Bagbin is going to abide by it. Because he had gone to them to argue that they don't have the power to determine what he does in Parliament. And he lost the case. And now, because he lost the case, he has refused to enter appearance in this case. So what is the guarantee that when Supreme Court rules today, he will abide by it, especially if the ruling should go against his decision? What's the guarantee? He is likely to accept it if it goes in favor of his ruling. Well, but assuming that the Supreme Court rules and it is against his position, where is the guarantee that he will obey?
He has no choice, because this one has more to do with constitutional interpretation.
No, so long as he disobeyed that Supreme Court in the first place by refusing to suspend his decision. His refusal to suspend the decision is why we are still here.
Elvis.
So I don't have any confidence that if the Supreme Court pronounced today, Bagbin will not sit in Parliament the next time and go and take another decision.
Elvis, you see, that's why I said that they are all being sly in this very particular. You remember the first time, what they did was that when he came, then he said, I've had this, the writ has been served on me. What is the writ? The writ that you suspend your decision. What he failed to do was to deduce from the writ. So he, in effect, he's telling you that I've informed the House, I have this writ. But like you are saying, on that day, if you are added that, based on the writ that I've received, please, whatever I said, it will now return. Let's wait for this. That is what he has refused to say.
And because he doesn't want to obey the Supreme, that's why he went to the court to go and challenge them and say they don't have the power to intervene in his decisions in Parliament, because he's also an arm of government. And I've said that is an argument that is so hollow, because the authority of this country is in the Supreme Court. Because we say the authority of God, the sovereignty of Ghanaians lies in the Constitution. And that Constitution says if there's anything about interpretations of law in this country, it is only the Supreme Court can do that. That is why President Mills dissolved the Bank of Ghana board. Senior lawyer Sam Okujedu went to court to challenge and said he doesn't believe that the president has that power based on the act. 4 years time, the Supreme Court said yes, the President Mills was wrong. President Akufo-Addo's debacle with Domelevo. Somebody went to court and said, by the act of the audit service, he doesn't believe that a president can direct the Auditor General to go on leave. The Supreme Court ruled that President Akufo-Addo is wrong and that a president has no power to direct an Auditor General to go on leave. If the judiciary can determine decisions of the president, who is another arm of government, how come Parliament is telling us that the same judiciary cannot determine what they do in Parliament? There are three arms of government. But the judiciary is above the legislature and the executive. Because when it comes to the interpretation of laws in this country, it's not executive, neither is it the legislature. The only authority is the Supreme Court.
When we return from the break, I want you to help us answer this question. Where from this thinking that MPs have said it time, without number, that they are their own masters of the masters of their own rules. I'll have you comment on that after a short break. We'll be right back. All right, welcome back. It's still the news review segment right here on Breakfast Daily, and we're having a very animated conversation on this issue of the Supreme Court and what to expect today, what has been happening so far and what to expect today. Now, I just want us to just quickly touch on the whole commentary that we've had several MPs make, that Parliament is a master of its own rules, and how does that play in context of understanding that the Constitution is the supreme law of Ghana, and the Supreme Court is the only body that's mandated to interpret what the Constitution says. Elvis?
Yes, they are the masters of their own rules, because the rules are to govern their conduct. That one, nobody will challenge them that somebody else will determine their rules for them in their house.
Okay.
But the issue at stake is not about only their rules. What their rules specify is also specified in the Constitution.
Okay.
So right now, their rules have become subservient to what the Constitution has said. So at this point, their rules cannot take precedence over the Constitution.
Okay.
If it's a rule in Parliament that the Constitution is silent about or has not said anything about, it's a different case.
Yeah.
But this particular rule that we are talking about, it emanated from a constitutional provision.
Yeah.
So if somebody is challenging or asking the Supreme Court to interpret that constitutional provision, it is the person is not saying Supreme Court should interpret their rules. When you look at the writ filed by Apenuma, it didn't say parliamentary rules.
No.
It says provisions in the 1992 Constitution have been violated or breached based on their argument, and therefore the Supreme Court should come in. So at this point, it is not about the rules of Parliament.
Okay.
It's clearly about a constitutional provision.
Okay.
So at this point, nobody can say it's the rules, they are masters of their own rules. Yes, it's their own rules if it has nothing to do with the Constitution. But so long as there's a provision in the Constitution that supersedes that provision in their rules, obviously the Constitution will take precedent. That's why the people are asking for Supreme Court interpretation. So for me, nobody should make that argument unless the issue at stake has nothing to do with anything in the Constitution, and that is purely about a rule. For instance, Parliament say come to sitting at 10 a.m. and you didn't appear, and they punish you. Where are you going to? Because the Constitution didn't specify the time you should appear in Parliament. You understand it? It is Parliament that said that rule that you should appear by 10 o'clock. So if they use the rules against you, what court are you going to? It's your own rules. So nobody will come and say, why did you send 10 o'clock for people to appear in the house? That's why the Supreme Court will not even entertain that suit. Because there's no point in the Constitution where it stated that this is the reporting time for members of Parliament. You understand it? So that one, Supreme Court will not come in. But this whole issue we are talking about, it actually emanated from the Constitution. And so long as there's a provision in the Constitution on that, then nobody can go to the Supreme Court to seek interpretation. So there's clear difference between the rules that Parliament is masters of and the rules that it cannot be masters of. And at this point, what is happening? Parliament is not a master of the Constitution.
Okay.
And that must be clear to everybody.